Hello everyone. My name is Sampa Karmkar Singh. I am Assistant Professor at WBNUJ's Kolkata. Today, we are going to discuss one very important and interesting topic termed as Alternative Dispute Resolution. It is also popularly known as ADR. First of all, let me introduce you to the concept of ADR. What are its types, its features, and we'll also compare it with litigation. We'll also see that how nowadays it is also known as amicable dispute resolution because it tries to resolve the disputes amicably. ADR refers to various amicable methods of dispute resolution outside the courtroom without resort to litigation. ADR methods are not new to India since Vedic times. India has been heralded as a pioneer in the achievement of the social goal of speedy, less expensive, and effective justice through informal but culminating dispute resolution systems. ADR includes arbitration, mediation, conciliation, lok adalat, etc. The goal of alternative dispute resolution is enshrined in the preamble of Indian Constitution itself as justice, social, economic, and political. The Indian Constitution guarantees justice to all, which are required to be rendered to the masses in its truest sense. The rising cost of litigation and backlog of cases in the court resulting in delay to resolve the dispute is making traditional lawsuits impractical and paved the way for alternative dispute resolution. ADR can be traced back in our country when disputes were settled by a council of village elders, known as panchayat, as an accepted mode of conflict resolution. Today, ADR mechanisms for settling disputes are so effective that even courts often require disputing parties to pursue these alternatives before litigating. Section 89 of the Code of Civil Procedure postulates an affirmative role for the courts in promoting ADR techniques by expressly providing for out-of-court settlement through alternative dispute resolution. In the ADR method, parties have the scope to participate in the solution-finding process. Thus, they honor the solution with commitment. ADR, especially mediation and conciliation, not only addresses the dispute but also addresses the emotions underlying the dispute. All forms of ADR present a number of key advantages over formal litigation. ADR helps to preserve and enhance personal and business relationships that might otherwise be damaged by adversarial court proceedings. Now let me introduce you with the advantages of ADR. Why parties should opt for ADR? It has lots of advantages, like it is less expensive, it is less time consuming, free from technicalities as in the case of conducting cases in law courts. Parties are free to discuss their differences of opinion without any fear of disclosure. So, it also provides parties confidentiality. Parties have the feeling that there is no losing or winning side between them, but at the same time, their grievance is redressed and their relationship is restored. So, by using ADR, parties are actually opting for a win-win situation. Constitution of India also provides various articles which are related to access to justice and also paved the way for ADR. For example, if you see the Constitution of India, through Article 14, it guarantees equality before the law and the equal protection of the laws. Article 39A of the Constitution mandates the state to secure that the operation of the legal system promotes justice on a basis of equal opportunity and ensure that the same is not denied to any citizen by reason of economic or other disabilities. It provides for free legal aid. Equal opportunity must be afforded for access to justice. It is not sufficient that the law treats all persons equally, irrespective of the prevalent inequalities. But the law must function in such a way that all the people have access to justice in spite of economic disparities. Article 21 of the Constitution of India, it provides and guarantees a right to life and personal liberty, which includes also within its broad ambit a right to a speedy trial. If you see this article, it states that no one can be deprived of these rights except according to the procedure established by law. Article 21 provides a basket of rights, and it also includes the rights to a speedy trial. Let me also inform you about one very landmark case in this regard, that is Husainara Khatun versus State of Bihar. Now, in this case, the fundamental right to a speedy trial emerged as an essential aspect of justice under Article 21 of the Indian Constitution. This case established that undue delays in the trial process were unconstitutional and that timely justice is essential for maintaining the rule of law. Access to justice. Now, if you see what this access to justice means, basically it provides the system must be equally accessible to all. It must lead to results that are individually and socially just. There is also Law Commission of India reports which provides the traditional concept of access to justice. The report is on the 222nd Law Commission of India report, which talks about need to justice dispensation system through ADR mechanisms. So if you see this Law Commission of India report, you will find that it informs you about access to justice. The concept as it is understood by common man is access to court of law. So when we say access to justice, a common man thinks that it is access to court of law. But the courts have become inaccessible due to various barriers such as poverty, social and political backwardness, illiteracy, ignorance, procedural formalities, and the like. To get justice through courts, one has to go through the complex and costly procedure involved in litigation. One has to bear the cost of litigation, including court fee and, of course, the lawyer's fee. A poor litigant who is barely able to feed himself will not be able to afford justice or obtain legal redressal for a wrong done to him through courts. Further, a large part of the population in India is illiterate and live in abject poverty, and it's an open secret. The Maneka Gandhi's principle, as enunciated by the Indian Supreme Court, that fundamental rights do not constitute separate islands unto themselves, but constitute a continent result in what Justice Krishna Iyer terms the jurisprudence of access to justice. Justice should be there in all its facets, social, economic, and political. You will find these words in our preamble of the Indian Constitutions as well. And it is required to the masses of this country without a further loss of time. As we have already discussed a little bit about the 222nd Law Commission of India report titled as Need for Justice Dispensation through ADR, etc., you will see that it provides that why we at all require ADR to keep under review the system of judicial administration to ensure that it is responsive to the reasonable demands of the time and in particular to secure elimination of delays, speedy clearance of arrears, and reduction in cost so as to secure quick and economic disposal of cases without affecting the cardinal principles that decision should be just and fair. Simplification of procedure to reduce and eliminate technicalities and devices for delay so that it operates not as an end in itself but as a means of achieving justice. Improvement of standards of all concerned with the administration of justice. The 222nd report also recommends reducing delays and costs, simplifying procedures, and improving the standard of those administering justice. Now let me inform you about one very interesting provision which was incorporated in the Code of Civil Procedure 1908, and it was through an amendment. This was inserted in CPC 1999. We are talking about Section 89 CPC. The enabling legal framework for the resolution of disputes through ADR has been provided under Section 89 CPC, and as I have mentioned that it has been incorporated, it has been inserted in CPC in 1999, and it provides for settlement of disputes outside the court. Section 89 has been introduced with the objective of providing speedy justice through arbitration, conciliation, judicial settlement including settlement through Lok Adalat, mediation. We also know about one very famous case, that is Salim Advocate Bar Association versus Union of India. In this case, the Honorable Supreme Court rejected the challenge to the constitutional validity of the amendment which was made in the Code of Civil Procedure or CPC. And the court held that we should endeavor to inspire parties to settle their disputes outside the court by more and more utilizing Section 89 CPC. It is a very beneficial provision. Now, as when we talk about alternative dispute resolution, the various modes or various types of ADR comes, that is arbitration, mediation, conciliation, judicial settlement through Lok Adalat, and hybrid dispute resolution, ODR. ODR means online dispute resolution. First, let me tell you about what arbitration is. So, if you see the Arbitration and Conciliation Act, the definition of arbitration is provided under Section 21A of the Arbitration and Conciliation Act. It defines arbitration as arbitration means any arbitration, whether or not administered by permanent arbitral institution. Section 21F of the Arbitration and Conciliation Act defines international commercial arbitration. International commercial arbitration means an arbitration relating to disputes arising out of legal relationships, whether contractual or not, considered as commercial under the law in force in India, and where at least one of the parties is an individual who is a national of or habitually resident in any country other than India, or a body corporate which is incorporated in any country other than India, or an association or a body of individuals whose central management and control is exercised in any country other than India or the government of a foreign country. The Arbitration and Conciliation Act has been amended recently thrice in 2015, 2019 and 2021. So, the Arbitration and Conciliation Amendment Act of 2015, it provided for expeditious, fast-track, and time-bound arbitral proceedings, the neutrality of arbitrators, and a cost-effective delivery mechanism. So you can see that it actually talks about the time and money, how we could save time and save money through using ADR mechanism, and it has made it a time-bound fashion. This was followed by the Arbitration and Conciliation Amendment Act of 2019 with the main objective of giving a boost to institutional arbitration and reducing the share of ad hoc arbitration in the country. So here you could see there are two terms, institutional arbitration and ad hoc arbitration. These are actually the kinds of arbitration. Further, Section 34 of the Act was amended by the Arbitration and Conciliation Amendment Act of 2021, which provides for an unconditional stay of enforcement of arbitral awards where the underlying arbitration agreement, contract, or making of the arbitral award is induced by fraud or corruption. Now we are coming to the second mode of dispute resolution through ADR, that is conciliation. Conciliation is also provided under Part 3 of the Arbitration and Conciliation Act. Conciliation is a dispute resolution process where a neutral third party called a conciliator helps the parties reach a settlement. In case of arbitration, students, please remember that arbitrator is the person who is the third neutral party to resolve the dispute. The party initiating conciliation shall send to the other party a written invitation to conciliate under Part 3 of the Arbitration and Conciliation Act, briefly identifying the subject of the dispute. Conciliation proceedings shall commence when the other party accepts in writing the invitation to conciliate. Also, let me inform you that when we talk about arbitration, the previous mode of dispute resolution, arbitration agreement shall be in writing. So, the starting point is you have to have some commitment in written format to start ADR mechanism either through arbitration or conciliation. Like in case of conciliation, when the other party accepts in writing the invitation to conciliate, the conciliation proceedings shall commence. If the other party rejects the invitation, there will be no conciliation proceeding. So here you could understand that how party autonomy plays the vital role in ADR processes. So parties, they have to give their consent, and if they provide their consent, then only such proceedings may take place. If the party initiating conciliation does not receive a reply within 30 days from the date on which he sends the invitation or within such other period of time as specified in the invitation, he may elect to treat this as a rejection of the invitation to conciliate, and if he so elects, he shall inform in writing the other party accordingly. Coming to the concept of mediation. Recently, the Mediation Act 2023 has been passed. This act is enacted to promote and facilitate mediation, especially institutional mediation, for the resolution of disputes, commercial or otherwise, to enforce mediated settlement agreements, to provide for a body for the registration of mediators, to encourage community mediation, and to make online mediation an acceptable and cost-effective process. The Mediation Act of 2023 provides under Section 3H of the Mediation Act, it defines the mediation. Mediation includes a process whether referred to by the expression mediation, pre-litigation mediation, online mediation, community mediation, conciliation, or an expression of similar import whereby parties attempt to reach an amicable settlement of their dispute with the assistance of a third person referred to as mediator who does not have the authority to impose a settlement upon the parties to the dispute. Section 3I of the Mediation Act defines mediator. So who is a mediator? Mediator is a person who is appointed to be a mediator by the parties or by a mediation service provider to undertake mediation, and includes a person registered as mediator with the council. It also provides one explanation. Where more than one mediator is appointed for a mediation, a reference to a mediator under this Act shall be a reference to all the mediators. Coming to the concept of Lok Adalat, you could see that it is a combination of two words, Lok Adalat. Lok means people, Adalat means court. So Lok Adalat actually means people's court. Lok Adalat have come up as a viable ADR mechanism available to common people. It is a forum where the disputes, cases pending in the court of law or at the pre-litigation stage are settled, compromised amicably. Under the Legal Services Authorities Act of 1987, an award which is made by a Lok Adalat is deemed to be a decree of a civil court and is final and binding on all parties. And interestingly, no appeal lies against thereto before any court. Coming to the concept of online dispute resolution or ODR. It is a digital space where parties can resolve disputes through negotiation, mediation, or arbitration. It can also be used to augment traditional dispute resolution methods by applying online technologies and innovative techniques. Hybrid alternative dispute resolution. Hybrid ADR is a flexible and efficient way to resolve disputes by combining two or more traditional dispute resolution processes. It can help preserve business relationships and is often used when a dispute may require elements of multiple processes. One example is MADE-ARB. A common hybrid process is MADE-ARB, which stands for Mediation Arbitration. In MADE-ARB, a neutral mediator attempts to resolve the dispute, and if that fails, they then act as an arbitrator and render a decision. The same person can act as both the mediator and arbitrator, or different people can fill each role. Justice dispensation through ADR. ADR methods, especially mediation and conciliation, not only address the dispute, they also address the emotions underlying the dispute. In fact, for ADR to be successful, first the emotion and ego existing between the parties will have to be addressed. Once the emotions and ego are effectively addressed, resolving the dispute becomes very easy. This requires wisdom and skill of counseling on the part of the mediator or conciliator. Dr. APJ Abdul Kalam, the former President of India, has been supportive of mediation and conciliation as ADR mechanisms and emphasized the need for their training in order that they are persons of impeccable integrity and ability to persuade and create conviction among parties. ADR methods. There is lots of flexibility in the use of ADR methods. The flexibility is available in the procedure as well as the way solutions are found to the dispute. The solution can be problem specific, and you can also think of out-of-box solution by using ADR mechanism. The rigidity of precedent as used in adversarial method of dispute resolution will not come in the way of finding solutions to the dispute in a creative way. The ADR method is participatory, and there is a scope for the parties to the dispute to participate in the solution finding process. The development of ADR methods will help in reducing the enormous workload that is put on the judiciary. This will go a long way in improving not only the access to justice but even the quality of justice. Section 16 has been inserted in the Court Fees Act, where the court refers the parties to the suit to any one mode of the settlement of dispute which is referred under Section 89 of the CPC. The plaintiff shall be entitled to a certificate from the court authorizing him to receive back from the collector the full amount of the fee paid in respect of such plaint. Justice delayed is justice denied. The phrase justice delayed, justice denied is often used to emphasize the importance of timely and efficient delivery of justice. When a legal system fails to provide justice in a timely manner, it can lead to frustration, loss of faith in the system, and even further injustice. The contrary concept is justice hurried is justice buried. However, a rush to judgment can also lead to incorrect and unjust outcomes. As a result, the phrase justice hurried is justice buried is also used to caution against hasty decisions in the name of expediency. Every case requires reasonable time, and that should be provided to the parties so that they could present their case, and both the parties should be given audi alteram partem or right of being heard. They have this right, so to represent their case, ample time should be given. And in judgment also, all the aspects should be taken into consideration. A hasty or rush to judgment may lie you in justice hurried and justice buried condition. ADR pre and post COVID-19. The entire world has faced the challenges attached to COVID-19. Dispute resolution was also affected due to COVID-19. However, technology has also opened up new avenues to resolve disputes through online mode and identified challenges to cope up with confidentiality, internet issues, and delays incurred in proceedings. Some recent enactments related to ADR are the Commercial Courts Act of 2015. It was amended in the year 2018 to provide for a pre-institution mediation and settlement mechanism. It is in short known as PIMS. The India International Arbitration Center Act of 2019, and as we have already discussed, the Mediation Act of 2023. Government of India at the forefront of promoting ADR systems, the disposal of pending cases in court, including those which are compoundable, lies with the exclusive domain of the judiciary. The government has no direct role in the disposal of cases in courts. However, the government has been making constant endeavors or efforts to provide an ecosystem for faster and more efficient disposal of cases by the judiciary. It has been a constant effort of the government to reduce litigation in courts. Several efforts have been initiated in the country over the years with the vision of a faster dispensation of justice. The National Mission for Justice Delivery and Legal Reforms was set up in August 2011 to increase access by reducing delays and errors in the system, enhancing accountability through structural changes, and setting performance standards and capacities. E-Courts Mission Mode Project. Under the E-Court Mission Mode Project, information and communication technology, that is ICT, has been leveraged for IT enablement of district and subordinate courts. Furthering computerization of the district and subordinate courts has been carried out with proper WAN connectivity, video conferencing facility, setting up of e-Seva Kendras in the court complexes and virtual courts, etc. under Phase 1 and Phase 2 of the e-Courts project. In 2023, the Cabinet has approved Phase 3 of the e-Courts with a budgetary outlay of Rs 7,210 crores. Taking the gains of Phase 1 and Phase 2 to the next level, the e-Court Phase 3 aims to usher in a regime of maximum ease of justice by moving towards digital, online, and paperless courts. It will be also environmental friendly. It intends to incorporate latest technologies such as artificial intelligence, blockchain, etc. to make justice delivery more robust, easy, and accessible to all the stakeholders. ADR program in 2017. The government launched the ADR program in 2017, which provided an effective and reliable e-interface platform connecting the needy and disadvantaged sections seeking legal advice and consultation. With panel lawyers via video conferencing, telephone, and chat facilities available at the common service centers situated in Gram Panchayat and through ADR mobile application. Finally, a successful judicial system is the hallmark of any developed civilization. In our country, the ratio between the population and the judges is unrealistic. Therefore, the judiciary is unable to cope with the flood of litigation. Number of cases are more as compared to the number of judges. Hence, the number of judges needs to be increased in proportion to the population. ADR mechanism is exceptionally beneficial for amicable dispute resolution. ADR mechanisms including arbitration and mediation are less adversarial and are capable of providing a better substitute to the conventional method of resolving disputes. The use of ADR mechanism is also expected to reduce the burden on the judiciary and thereby enable timely justice dispensation to citizens of country. With the advent of the ADR, there is a new avenue for the people to settle their disputes. More and more ADR centers should be created for settling dispute out of court settlement as it is being done in many other countries. ADR methods will really achieve the goal of rendering social justice to the people, which really is the goal of the successful judicial system. The ADR movement needs to be carried forward with greater speed. Thank you so much for your patient hearing. Stay connected with me for my next video. Thank you all.